Policy on Record, a public policy podcast powered by Vidhi Centre for Legal Policy through Kautilya Society, Symbiosis Law School Hyderabad, where we decode public policy for the curious and the critical. On the focus today is the Digital India Act, which is India's most ambitious attempt yet to regulate the internet, ensure data safety, and deal with new age technologies like artificial intelligence. The timing for this act couldn't be more urgent, with the cybersecurity threats, deepfakes, and digital misinformation being no longer fictitious. Shows like Special Ops 2 might exaggerate it, but the policy threats that they point to are very real. Joining us today is Professor Tushar Sharma, faculty in charge of Kautilya Society, Symbiosis Law School Hyderabad, and Professor Annapurna Devi Munaganti, faculty in charge for Centre for Cyber Laws and experts in technology law and data governance. Welcome, sir. Welcome, ma'am.
Thank you, Aiswarya.
Okay, sir. So let's start with the basics. Why does India even need a Digital India Act? Why not just amend the IT Act, which has been regulating the internet since the 2000s?
See, Aiswarya, I'll say that's a very fundamental question you have asked. So, imagine you bought a basic feature smartphone in 2000. So, that is great for calls and SMS. So, now if you try to incorporate your modern apps, video calls, and your payment apps in that same phone only, so it just won't work, right?
Yes.
So, precisely this is the same situation with the IT Act 2000. So initially it was made just to give legal recognition to the paperless document, right? So now if we talk about from watching something, or let's say you guys are taking online classes, for just even booking the medical appointments, it all happens online, right? So that's why we needed the Digital India Act. So sometimes it is better to not fix the old furniture again and again. So it's better to incorporate and to build the new house, right? So I think that is the reason why we need a new Digital India Act.
So you mean to say that the public policy must adapt and evolve with the ever-evolving technology and the generations?
Yeah, because if you see that our competitive United States and European Union, they are emerging with and they are adopting with the emerging technology. Now we have our old Act, IT Act 2000, right? And although we have made few changes, like in 2021 we have incorporated that intermediary guidelines, but that is not enough. Now we have a technology like blockchain technology, then we have deepfakes, then we have IoT devices. So that is not enough for IT to handle.
Right.
Yeah.
So, ma'am, can you give us some focus on the augmentation of universal digital connectivity in India and its step towards the Digital India Initiative?
Yeah, definitely, and thank you very much for giving me this opportunity. And even I wanted to little focus on the Digital India Initiative. Before going to look into the implications of the new proposal legislation, whatever may be, first of all, we need to look into the entire Indian universal digital structure. Now, basically, the government for the past 10 years period of the time, since 1 decade period of the time, it has been focusing on increasing the capacity of the digital infrastructure. So, like that, it has segregated the entire cities into Tier 2 and Tier 3, and also like the rural areas. Now, if you look into how significantly we can see there is a universal, like the digitalization that is happening in India, even you can see as per the data provided by the Press Information Bureau of March 2024. Here, like almost like in India, we have 900, around like 955 millions of the internet users are there, and out of that, almost nearly 400 millions are from rural areas. Okay, so the users have been significantly increased in rural areas. Now, if you look into that, there are almost like 95% of the villages having internet access. So it is like one of the remarkable change. You can't even see this kind of significant change even in majority of the interior places of Western countries also, but India we secured that one. Now another important thing is that like according to 2014 there were only 251 million of subscribers out there, but now it is almost like increased to 955. And in addition to that, nearly as per the data, 95% of villagers have been started using internet access. They are getting access to like the content, everything. And also you can see that how significantly, even every day you can see so much of content has been generated by each and every individual, like so active. Now we need to ensure of that to what extent this particular data that is being available in the online platform or digital media is being secured or is being safe, etc. Do you think so? Like this particular content is most trusted, and what kind of accountability that particularly who are acting like platforms, messaging platforms, how they are acting, whether they are acting on a responsible way or whether they are acting in an accountable way. Like you need to look into that. So ultimately, the Digital India enactment, the proposed legislation, so not yet coming to force, it is mainly focused on some of the basic fundamental things like the openness and also like the trusting of the specific content, and also when you look into that, mostly like the safety. Because sometimes the kids also they used to upload their videos. Like what kind of protection that we are giving, that we need to look into that. So ultimately, still it is like an unopened kind of discussion, because like we have not come across what exactly the appropriate wordings have been given. That to now here the legislation which has already been proposed along with this data like digital initiative enactment, it has like the Digital Data Protection Act has already came into force. Now in consonance with this DPDP Act, how DIA like the Digital India Act supposed to be taken into consideration, that you need to look into that.
Yes, ma'am. So, what about personal freedom and what about privacy when you talk about regulation and governance?
Yeah. Personal freedom and privacy, I feel like both are same only, but in the context of your DPDP Act, it's like the personal information you need to look into that. Okay, sometimes like what the content that you are putting, whether it is your private life or whether it is your thing, there are some kind of limitations also. See, conceptual understanding is that suppose what is considered to be personal may not be considered for some other person because they wanted everything to be open. But there are sensitive information is there, like with respect to the date, with respect to the sex, with respect to the specific passports, etc. Considered to be more sensitive information, and this is considered to be personal data. Okay, there apart from that you need to check it properly, because so many of them they might be confused about the confusion between personal privacy and also like the personal data. Okay, because like privacy is something like some people they don't want to put or they don't want to display their photo in any social media, but most of them they will give so much, they will put the GPS location, everything, that is their privacy. But when it comes to the sensitive information, when it is affecting the major interest of the vested interest of the individual concerning, like the child, minor whose interest has been taken, that you need to look into that. So that is the reason why clearly DPDP Act has been kept digital personal data protection. That's what. Anyway, like we are the lawyers, like we will do a lot of like inferences, but this is like the conceptual understanding. That one.
Okay, sir. So that brings us to the structural reforms. What are the structural reforms that the DIA proposes?
See, the Digital India Act is really about building a new framework for our digital world. As I mentioned that in our previous IT law, there are few structural gap that it has only covered the legal recognition part. And if I talk about the major change, now it has classified differently for the intermediaries, like in our old IT law. Whether it is a social media company or a cloud-based server or an internet provider. So in our IT law, they were in the same umbrella, right? So in our Digital India Act, they were kept separately. You can think of like that instead of treating all the vehicles on road the same, right? So they have made different rules for two-wheeler, different rules for cars, and different rules for truck. So just like that, now we have different rules for social media platforms, different rule for the internet providers and different tools for the cloud-based system, because now they are liable on what they provide and what they do, right? So this is the big change I mean they are making. And the second thing I'll say about it, there is a thing called safe harbor immunity. So that is given under section 79 of IT Act. See, earlier intermediaries were not liable for the users, posting or something like that. So, I mean, they used to say like that we are just providing the road. We are not responsible that how my users is driving on that particular road. So that is not the case with the Digital India Act. Now they are being held accountable, right? And let's say if we found that if there is deliberate misinformation and other harmful content on their social media, so they would be held accountable accordingly. And also I will say that now they have a strict legal duty to fact check that whether this content is allowed or not. And apart from that, also they are also coping with the new emerging technology like 5G, IoT devices, blockchain, and deepfakes are coming in. So as ma'am has mentioned that it is not enacted yet, so it is still in the making. So we will see all of those changing, all of those changes in our new Digital India Act.
But in continuation to the SARS response, like even I wanted to tell you, like see, when you observe Information Technology Act, even DPTP Act, or even the new proposed the DIA Act, all of them are having a common connecting factor. Mainly they have emphasized on that the platforms, intermediaries.
Yes.
So see, intermediaries, like when you look into Information Technology Act, like they have come up with specific rules of, okay, but again in the Digital Data Protection Act, how these platforms are ensuring the consent taken from the users, that it has to be taken into consideration. But when you look into the proposed DIA Act, how this content has been used by newly emerging technologies and also disruptive technologies. Specifically they have used. So ultimately in either of the three legislations, one legislation can forego with another. But now when this new legislation comes, the DIA, like it might be like the replacing of the existing ITI. But to this extent, even prior to that, there was a bill called as Convergence of Technology. Long back, it has been proposed long back, where they wanted to implement this particular bill. It came after 2000 Information Technology Act came into force, because this Convergence of Technology bill, it merges all the technologies, not only the digital, telecommunication, etc., even your TV, cable, all these things will come under the same streamline. But unfortunately, even the then NDA time, it didn't come. Okay, and now here this particular enactment, as we have to know, we need to look into that, how it is there. Yeah.
Ma'am, so coming on to the point of newly emerging technologies, coming to AI, how do you think DIA proposes to regulate artificial intelligence, and whatever provisions that they put out for artificial intelligence, do you think they're adequate?
Technically, like currently, like we cannot ascertain what exactly the relevant provisions of the sections have been mentioned with respect to this, and to what extent the legal protection has been given. But when you look into this, like the Digital India, whether it is proposing to regulate artificial intelligence or not, do you think this new this particular enactment is being adequate enough? We need to look the two important concepts, like what is the responsibility aspect and what is the accountability aspect. Because see, according to Lauren Levine, he is one of the professor, and he specifically emphasized on the regulation of cyberspace jurisdiction. He mentioned that there are 4 important areas where cyberspace can be regulated. Okay, here we are talking about online content. I'm talking about his views. So like law, norm, architecture, and also like specific program. Like these are the 4 important market conditions. 4 things are there. So law, norm, architecture, and also marketing conditions. All factors will be subjected to regulation.
Yes.
But law at the central level, norm at the policy level of that particular program. And then with respect to the third category, that is like marketing, the business activity, and infrastructure. Infrastructure, like how the program has been developed. Now here, no law is talking about the regulating aspect of the articles. Why? Because that is purely based on the program, the step-by-step analysis, and also they need to follow specific international standards. Like in India, for privacy issue, they follow ISO 27000. That is the standard.
Yes.
So like with respect to the fourth category, like the infrastructure part, which was being defined by Lawrence Design, like basically this is like the policy. Like you need to follow specific standards where law doesn't have any role to play until unless like the some kind of compliances, and it will keep ensure of whether standards have been made. Even that too on the basis of the specific testing, even the analysis that the report given by the concerned programmers or concerned institution, then only on the basis of that infrastructure can be regulated. But now what is happening is that when you are taking about the AI accountability or the algorithm accountability, basically under the Digital India initiative, where this particular legislation is focusing, just like the EU AI Act. Like under the EU AI Act, very recently even the EU has come up with a new regulation where it has been clearly mentioned that AI can be super like somewhere like everywhere like a human intervention is required. Unsupervising machine learning or unsupervising AI doesn't have any specific regulation. So now when you look into that, the term algorithm accountability, where the AI is being involved, it involves more accountability that also legally they need to enforce their obligation. So now here we need to understand to how far extent here the concerned laws or provisions or rules will interfere into the pure functionality aspects or specific infrastructural policies of the particular like a particular company or a software or specific institutions, etc. So that part. And also like another important thing, we have already discussed about European Union AI, but even for that basis also GDPR is one of the main important regulation. Even on the basis of the GDPR also, here in fact, like because of the implication of the GDPR, India also forced to make certain laws in compliance with the international law. Why? Because we are in contact with international trade pacts with the European Union. So because of that, we need to bring even our national laws also in compliance with the EU standards. So that is also another important thing. So that's why when you cross check it, like how far infrastructure, particularly AI, with respect to machine learning, who will take the accountability? That is main important question. If you are taking accountability legally, who will bear the responsibility of imposing like performing any specific legal obligation or providing compensation, taking the accountability, etc. But what we can come across is that this machine learning system as a technical artifact, they cannot held accountable. You need to give that accountability to some organization or some institution, because stakeholders' interest is adversely affected. So that is main important thing. So here public and private regulators such as auditors and certification bodies, they can implement different mechanisms to hold organizations more accountable. So all these things. And apart from this, here in India, because we didn't enacted this DIA, we have even the provision, as Sir has already rightly pointed out, the safe harbor rule. As an intermediary. Now even they are considering, even like some aspects they are considering AI also. So AI considering as an intermediary, they are subjected to safe harbor rule provided under section 79. And read with section 69 also of the Information Technology Act. What section 69 of Information Technology Act is talking about? Interception. Interception is like whenever these kind of issues are coming, the government by any specific judicial order or any specific legislative order, they can intercept the entire network service providers or any specific providers, etc. So this is subjected to again the rules mentioned under Rule 4 of the intermediary rules that you need to look into. So all these are supplementary and complementary together, like Section 69, Section 79, and also Rule number 4. So all these things you need to look into that. But anyway. We do have different proposals, we do have policies also on national strategy of AI. This is also on the similar lines of European Union AI Act, like low risk AI, high risk AI, acceptable, unacceptable AI, and then the last one is like prohibited AI. So they are expecting at every level here AI need to be having human intervention, and also like AI should not be more narrower. You need to understand that narrower and broader, or narrower or general. General is like AI can help in data analysis, etc. But in narrower, AI can have the ability of taking decisions, etc. That's what.
Right now. Okay, sir. So let's bring in the DPDP Act. How do you think the DPDP Act and the DI interact, and do they overlap in any aspects?
See, DPDP is very much focused to the individual rights and the personal data. Like for example, suppose a company collects your name and information,
Yes.
right? So DPDP ensures that they must have your consent, and and they must have your consent, and they use the data what they have stated for the consent you have given. And if we talk about the Digital India Act, right? So it governs the broader conduct of the social media platform, right? And it looks at things like how platform should deal and how AI should deploy. So I mean, I will say that they are designed like they are the opposite sides of a same coin.
So, ma'am, coming back to the topic of traceability, like which is a really big hot topic right now, DIA proposes to trace the messages back to the originators. So, don't you think this compromises the concept of end-to-end encryption and personal freedom and privacy of an individual?
Yeah. Specifically, like simple example, suppose some kind of video that is of porn content relating to a particular woman and man, and it has been circulating in the WhatsApp group, for example. So when this particular content has been circulating, like exactly we need to ascertain like where exactly the originator that has been started, like where exactly this particular message has been started. But sometimes because this particular content itself is fake, okay, then by using some specific AI tools, etc., they have morphed, and they have even, just like what happened in the recent celebrities case also, like when all this procedure is been happening, particularly it means sharing in the WhatsApp group, now one can ascertain where exactly the real source is. Like for example, you take the email, when you have a defined email ID, even if you take any specific system that you got a message, they can take the GPS or the IP address, etc. But suppose if it is happening, some app that has been downloaded, and that app is of AI unbounded. Now, end-to-end encryption is very much difficult, and it is too much interfering into the specific infrastructure of that. Now, who can make responsibility in such cases? Again, we need to go back to check into the rules also to that extent. So that's why here again, earlier like the application of this section 4 clause 2 of the intermediary rules, even it has also a provision of traceability.
Yes.
But the scope of traceability is only subjected to limitations, but also you need to check in some cases whether the adequacy of this particular provision to the AI tools has been taken into consideration or not. And the second part of your question, like with respect to how this particular traceability can be like implemented, that anyway we need to look into the entire adjudicating mechanism, the concerned authorities, how they are taking into.
Sir, so how do you think India's proposed framework compares with the global standards, like let's say the EU's Digital Services Act or the US approach?
See, if I talk about European Union, they are clearly leading away. I mean, they have this right-based approach, Now, right-based approach means they have this top-down comprehensive regulation, which means that they are telling their platform that you have a certain responsibility towards your user and society,
Yes.
And we are monitoring that, right? And they are monitoring through laws like DSA you have mentioned, and GDPR they also have. Now, in contrast, if I talk about United States, so they are still debating on their federal privacy law. So I mean, they often rely on their state laws and their agency regulation. But I will say that it is very complicated for the technology company to keep follow up the same thing for the different jurisdiction, right? So if I talk about our Digital India Act, so our Digital India Act brings an attempt to bridging between these two philosophies. Right. So let's see. I mean, it's still in the enactment stage. So let's see what's there out.
So, ma'am, how do you think this online content or series, let's say, for example, like the special ops, are actually reflecting the actual cybersecurity threats that the India faces today? Do you think they're portraying it accurately, or they're just exaggerating it to a point where it's not real anymore?
Okay. So like to this particular question, definitely like technology is something like that is only the area of the concerned experts.
Yeah.
Okay. Now when you look into this particular aspect, like how they are portraying it, in particular open sources like OTT, etc., or in YouTube also sometimes they used to give specific training how to crack or hack, or even how to make some specific algorithms, etc. But when you look into all these things, like, yeah, some do have the right content and even the good content, but when it comes to the availability of the information, sometimes it may be also gives a wrong direction for the users also. But anyway, see, whatever may be the information that is available, and maybe like they are being keep updating, it is having adverse impact even on the critical infrastructure like healthcare, even the grid system, or even the banking, etc., like that. So for all these things, what we need to ensure is that like we need to build first of all the capability, like the capacity. Anything, first of all, even if you are having a if you are having a critical infrastructure also, you need to have a properly maintained computer systems, all the supercomputers, whatever may be, whether now everything is in quantum computing.
Yes.
Like you need to ensure of all these things, whether you having any safety standards that you have been taken at that particular level or not. Unless like if you are not sure of that, but who maintains or who gives that guarantee that this particular is having like a tight way of secured mechanism. So we do follow cyber security policies, etc., but these are independent bodies guided by that. So again, private sectors will play into role, and whenever any law supposed to be made with respect to the imposing of obligation, it is completely the stakeholders' interest, particularly the companies who are involved in that, in making the policies, etc. So like even traceability aspect,
Yeah.
also this is one of the big challenge, because when there is compliances between policy and also traceability, personal data or the privacy will get affected. That is the reason why in one point of time, even the investigating department also, while using forensic tools itself, these forensic tools through the logical algorithm, it is interfering into the privacy aspect. Like when you are making any imaging of a particular evidence, that this particular evidence can also interfering into the privacy, or something, that information what not supposed to give permission, that can be get access, and again that is the basic competency of that particular evidence. So ultimately it affects the credibility and also appreciation of that evidence also before the court also you need to do. So lot many consequences are there.
So, talking about the strict governance and regulation, don't you think this will affect the India startup ecosystem or the FPI inflows? Like talking about end-to-end encryption, now that DIA is saying that that's not going to be the case anymore, do you think investors like WhatsApp, let's say, which is the main starter of end-to-end encryption, will even decide to stay in India anymore, or will the new investors even come to India considering all this strict regulation?
See, investors love certainty,
Yeah.
right? And they know that what they are getting into. So let's say if we have a vague rule and if the regulations are very uncertain, so I don't think that any investor will come. And for that thing, in Digital India Act, we need to maintain and we need to make the well-defined rules. And like I'll say that, like for example, that there is some AI startup who is building a great product, but right now they feel being uncertain, like how their AI will behave. So in that scenario, I will suggest the government that they have to play the smart here. They can provide the regulatory sandboxes. I mean, where that AI startup can basically practice their innovation without fearing any hefty charges or fines. So they can take inspiration from RBI, like what RBI did with the fintech startup. They have made the regulatory, sandboxes.
Yeah.
So we can do like that. So in that way, I will say that we can attract, billions of investment.
Right. So, do you think the Indian technology has the capability? Let's say that investors are not ready to come. Do you think we have the capability to start up our own mirror apps for, let's say, Meta, which is under WhatsApp, which is under Meta, or Instagram, which is under Meta? Do you think we have the technological capability?
Yeah, we are doing that. I mean, if you heard that OpenAI is ChatGPT, right? So in comparison to that, we have our Perplexity, right? So Perplexity is made by the Indian, right?
Yeah,
so,
and I agree. I think it's much more efficient.
Yeah, I mean, we can.
Yeah.
Even the CEO of Google is Sundar Pichai. I mean, that's a different debate that they have on American citizenship and all. But I mean, we are very much capable of, building our own thing. But we need investment, right?
Right.
So, yeah.
Ma'am, so what do you think is the biggest challenge for the DIA? Like, do you think it's surveillance, under-regulation, or over-regulation?
As of now, I cannot give any specific certain answer.
Yeah.
Because one thing is the DPDP also considered to be a specific surveillance only, but on whom? On a particular, the mechanism that involved the corporate bodies who are taking the information on consent, etc., how they are using, how they are storing, etc. Now, with respect to the what you call surveillance, whether this particular enactment is doing over-regulation or under-regulation, all this comes into only once we start applying it. But one thing is that every individual is having a basic right. Okay, two things are there. One is the right to express themselves. Okay, another thing is that when some content has been uploaded and this content need to have a proper secured way of the safety. If suppose if I am uploading some information, I am legitimately expecting that this particular content need to get protected of mine.
Yes.
Okay, so at the same time, if the object of that particular content where I uploaded, if it is not, if it is completed a task, for what purpose, then I have also a legitimate right to make sure that that particular content, right to be forgotten also. With respect to the surveillance, whether the DIA Act is over-regulating or under-regulating, that we need to relook into that. But as of now, we need to see how much content that has been uploaded by the users, and content moderation is very much important. So this is nothing but the issue between the right of an individual to express, and again at the same time how his right supposed to be protected through the online medium. Okay. Now another important thing is that as of now DIA, we cannot completely say whether it is under-regulated or over-regulated. We need to look into the provisions again. And as of Information Technology Act, yes, there is some gap is there, because might be that is the reason why Digital India Act would be coming into force to fill up those gaps, so that I think this particular legislation can have adequate applicability proportionately to meet its objectives.
The Digital India Act will be one of the most consequential pieces of legislation in Indian digital history. Whether it safeguards liberty while promoting innovation depends on how it's legalized, legislated, implemented, and scrutinized. This was Policy on Record, a Kautilya SLSH Originals podcast. Stay tuned till our next episode. Until then, read, reflect, and engage.